No, no, that. You're welcome. We'll be checking some learned friends of ours.
Amen. The Public Secretary of the DEP.
Hi, good evening and welcome to Political Talk with Christy. Today we are delving into the legal and political higi-haga that has engulfed Rivers State. A powerful group of Rivers political leaders has petitioned President Bola Ahmed Tinubu, urging him to halt the upcoming local government elections. Their argument is a powerful one. A sole administrator appointed under an emergency rule lacks the constitutional authority to conduct such polls, so they say. But there's another side to this story. We've seen evidence suggesting that the president, acting under the powers granted him by the 1999 Constitution section 305, may have suspended or modified certain laws to ensure these elections proceed. This pits a foundational principle of democracy against the extraordinary powers of an emergency decree. Now, to help us navigate these complex legal and constitutional questions, we have a distinguished guest, a man of letters and law, a legal titan in the making. I am proud to welcome Achi William-Wobodo Esq, a senior advocate of Nigeria in waiting. Thank you for joining us, Barrister Wobodo. So you're welcome, Barrister Wobodo. Yeah, let's get straight to the heart of the matter.
Thank you.
Yeah, the letter from these Rivers elders is based on a specific legal claim that a sole administrator lacks, under an emergency rule, lacks the power to conduct elections. Now, as a legal expert, what is your initial reaction to the position? Is it legally sound?
To them, I understand their plight. Maybe they are not seized of constitutional law and how start able to understand that the sole administrator in vacuum, the sole administrator acts based on powers derived regulations pursuant to powers conferred on him by the Constitution. Now, let me start by giving a prelude to the matter for those of the audience who may not be totally aware of how this matter started.
Yeah.
Now, the Attorney General of Federation, for the interpretation of the Constitution, Section 7 of the Constitution precisely, and then the Supreme Court gave an order to say that any local government that does not have the state organogram cannot draw from the federation account. Now, quickly, immediately after that was done, the Rivers State government, out of panic of emergency. Now, the state of emergency was declared back March 2025. Now, upon declaration of that state of emergency, which was Senate in accordance with the Constitution. Now, once there's a state of emergency, civil rule, civil laws are put in abeyance. Emergency area back to democratic system. State regulations made president pursuant to his powers under the Constitution. It is based on that regulation that the sole administrator was appointed. It is based on that regulation, those regulations that the administrator presented, the president presented budget to the National Assembly. It is based on the regulation, those regulations, that activities so far, have been going on in Rivers State. So when people say that the sole administrator does not have powers to conduct local government, they seem to forget that acts based on the authority. And in this case, the President of the Federal Republic of Nigeria has passed a regulation titled Emergency Power Local Government Conduct of Local Government Election and Election Tribunals Regulation 2025, which was gazetted on the 22nd of July 2025. Now, that is the power upon which the RISEC, by the way, not the sole administrator, the RISEC, Rivers State Independent Electoral Commission, is empowered to conduct the election. So it is not per se the sole administrator that is conducting the election.
Okay. Okay, so what you're saying is that in spite of their claims and then the petition written or the protest letter, that the RISEC, under the sole administrator has the right to conduct, to go ahead and conduct this election. Okay. Barrister Achi, I want to say something here. We've been through this kind of situation before now. They also mentioned it in their letter that the conditions precedent, to the conduct of the elections, that made the Supreme Court to nullify the last local government elections, conducted by the governor. They seem to be the same conditions, some form of illegality also taking place again. But you are saying something differently. Can you please expatiate more? Let us understand the difference between what is going on now and what happened in the past, because we don't want a situation where Rivers State resources will continue to be plugged into something that the Supreme Court will nullify at the end of the day. Because from what they have said, it looks like somebody wants to go to court to probably challenge the powers of the president. Don't forget that they also mentioned that the issue of state of emergency, the legality of the sole administrator is a matter before the courts. It's still yet to be tested by the courts. But clearly, Section 305 states that the president can actually declare a state of emergency when there are certain conditions met. So please, can you just let us know why this one is different and why they must go ahead with the conduct of the election?
Okay, thank you very much. You see, like I said, those who are advocating this, I see them, with all due respect, I see them as partisan members of parties. They don't get to think through from the process. Now, there's a clear distinction between the election of October and the election that is about to be conducted in August. Okay. The distinction is in the instrument of the conduct, the instrument for the one. Once the court an order saying that all local governments, all caretaker committee arrangements should be abolished, the RISEC ran to court, ran to street and conducted election without giving a notice. Now, the authority, the enabling authority for that election was the Rivers State local government electoral law. Okay. Now, that electoral law provides specifically for 90 days notice to be issued.
Okay.
Now, that 90 days notice was never issued. Now, under an emergency situation, which is the current situation where Rivers State finds, as I've said, the powers of the president within an emergency system, enables him to make regulation. Now, for the post-election, put in abeyance, suspended Section 7 of the Act and all those relevant sections of the letter, which says that 90 days must be given. Okay. And so the president, because of the emergency situation, directed that, based on his powers, directed that 30 days notice should be given. And the 30 days notice was given by Electoral RISEC when they made that publication on the 28th of July. Now, that is that. Now, for some of us who are lawyers, we think that they are doing it for the purpose of, not really assuring the legality of some of the comments they make. The president declared a state of emergency in Rivers State on the 18th of March, 2025. That was like 5 months ago. By next month's claim or people establish Officer Act, which you intend to challenge, you must do so within 3 months.
Oh, really?
Now, 3 months has passed. So coming to challenge the legality of the state of emergency declared by the president after 3 months, you also need to cross the hurdle of showing that the cause of action is not statute bad. Again, they cannot also claim that they want to challenge the conduct or actions of the sole administrator. You cannot, if you want to challenge the action of the sole administrator, you have to do so on a presumption that you have considered that the president has the power to appoint the sole administrator. So if you want to challenge the activities of the sole administrator, you must first presume or concede that the president has the power to appoint the sole administrator. And then upon that premise, you can challenge the activities of the sole administrator. But if you do not want to concede that and claim that by any dint of imagination, you also challenge the right of the president to appoint a sole administrator, you will contend with Section 2 of the Public Officer Administration. It's like why they cannot sue the sole administrator alone. It's like the sole administrator is an agent of a disclosed principal. The principal of the sole administrator is the president. So you cannot sue the president, you cannot sue the sole administrator who is an agent, and you leave out the principal who is the president. So for those of them who are challenging, I see it in that it's I don't want to use the word dead on arrival, but I see it as a very Herculean task for them to be able to establish. What I'm saying in effect is that the claim is that the president, in the regulation for the conduct of this election, suspended the 90 days, the section where the 90 days notice is required. Let us even take the other part of the argument. You understand? Assuming but not conceding, the argument is not correct. There's another aspect of the argument. That aspect of the argument, the Rivers State Independent Electoral Commission is an agency of government with perpetual succession. So using the local parlance, soldier comes, soldier goes. So that's in a RISEC issued a notice in March that it was going to conduct election on the 9th of August, that's today. RISEC has not set aside that date. There is no court of law that set aside that date. Okay. That date subsists. Now, what RISEC did 28th of July was to say, I was there live. I wanted to hear it myself. RISEC said, we are postponing the date of election. So what RISEC did was to postpone the election that was fixed for 9th of August and moved it to 30th of August. the Supreme Court has interpreted it in a lot of cases that when it comes to the issue of computation of time for notice of an electoral act, it is the time begins to run from when the initial notice was given. So the initial notice was given by RISEC in March. And so far, the notice has exceeded 100 days. So the argument is neither here.
Wow. Well, Barrister Achi, thank you for shedding light on this very important and intricate issue. Your insights have been valuable. Unfortunately, we don't have much time. And then again, the network has been erratic. In fact, we can't wait to have you in the studio, because I still have a number of questions for you. Thank you for sparing your time and also for giving us,